wouldn't know unless I told you. It's like this weird design. Look really, really close. I don't Mickey Mouse head before.
Hey folks, welcome to the new 4th District Court of Appeal. We're glad you're here. We're going to follow the docket as was published, and we'll let you all proceed, please.
May it please the court. My name is Howard Kahn. I represent the plaintiff, Jeffrey Shapiro, derivatively on behalf of Chiropractic Spinal Health. I'd like to reserve 4 minutes for rebuttal, if that's permissible, Your Honor.
Yes, sir. And actually, that whole clock there, that's your full 10 minutes. So when you get down to the 4 that you've requested, you just want to kind of keep note of that. Okay.
Got it, Your Honor. Opposing counsel. Your Honors, we are here today to ask this court to reverse the amended final judgment dated July 20, 2016, on the order dated October 22, 2013, granting summary judgment on each of the claims of action asserted in the derivative complaint that were barred by reason of Judge Connor's ruling by the statute of limitations or the doctrine of laches. We believe that we have created a factual issue for this court to consider on an appeal based on the statute of limitations, which has a de novo review by this court, based upon our derivative complaint. In the derivative complaint, which is verified, we set forth the facts that the reason the action was not timely brought was because the...
Can I ask you a question about the sufficiency of our record here? How are we to determine if the trial court erred without the motion for summary judgment, the response, the transcript? How are we supposed to do that?
Your Honor, there is an entire record on appeal. The entire record on appeal, though, is in the 2003 case that had been consolidated with this case, a 2011 case, many years ago. When we had the hearing on the final judgment on June 28, 2016, Judge Souter made an oral pronouncement that he was no longer going to consolidate the case. So, Your Honor, to answer your question, there is a summary judgment motion, there is a ruling, there is a transcript, there's a motion for rehearing, there's an order on that, and I have attempted to bring those issues before the court in this record, but by various orders of this court, my efforts to bring any of the papers that overlap between the 2003 case and the 2011 case before this court have been stricken by this court. I tried to do that through...
It's our fault.
Your Honor, I am not casting fault on anyone. There is no question that the clerk of the court at the 17th Circuit clerk of the court filed the complaint, the verified complaint in this case, in the docket on the 2011 case. After that, the case was almost immediately consolidated by an agreed order between the parties. Notwithstanding that, there were certain papers that the clerk continued to file in the 2011 case, but the vast majority of the cases, papers and pleadings, including the summary judgment motion, which was directed not only to the verified derivative action that you have before you, but also to counts in the 2003 case, were filed in the 2003 docket. When an issue came up in this case about what was being appealed, the order is from the 2011 case, but the clerk of the court filed it in the 2003 case.
Did you ask for relief in the lower court to have it filed in the proper case?
No, Your Honor, because there was no improper case before this went up on appeal. In other words, while the case was consolidated, there was no reason why the clerk would not file it in the lower case number, which is the 2003 case. That's what governs. That is my understanding of the procedure. that it would go to the earlier filed case.
When did Judge Souter unconsolidate the cases?
He made a verbal pronouncement at the June 28, 2016 hearing, right before when he granted the final judgment at that time. He said this case no longer needs to be consolidated, but it was never reduced to an order. So
Why not?
It just didn't happen. I don't have a better explanation. And Judge Levine, you're absolutely correct. I know the case law. I'm not trying to stand in front of this court to be admonished as far as what the record is that you would want to consider on an appeal.
I'm not casting blame, but you know also the burden's on you.
Absolutely. And I attempted repeatedly to comply with that burden, but I can't control what the clerk of the court says. I could not find any case law, and believe me, I tried to find case law as to guidance as to how to proceed at this point. I had asked for this court to relinquish jurisdiction at an earlier point in time, and the court said it was moot. It was not necessary at that time because we would proceed with the 2011 appeal. But I never, most candidly and most respectfully, never expected that the record could not be more adequately prepared, and I know I'm coming down to 28 seconds. So I'm cognizant of the issues. I'm cognizant of the law. I'm cognizant of the rules of procedure. But I did not expect to be in front of this court without a proper record, and that record exists. I would like this court to consider that record. Alternatively, there is nothing opposing the verified pleading that is not on information and belief, that the court could, in its discretion, reverse the summary judgment based upon that. I believe I'm out of time. Do I need to stop? Oh, you reset it.
No, yeah, we'll get it. Thank you. Morning.
Good morning, Your Honors. If it please the court, my name is Michael McLeod, and I am here to represent with Ms. Bellin and Mr. Oberweger the interests of the appellee, Dr. Garrett Weinstein, D.C., Garrett R. Weinstein, DCPA, and Chiropractic Spinal Health. As I get into this, and I can represent that I was not the trial court lawyer, was kind of brought on to handle this appeal and some other issues in the lower court. I found myself, and Ms. Bellin definitely found herself, in the same position as the court, trying to figure out how we handle an appeal without a record. The very first thing,
Sounds like you tried to make a record.
Excuse me?
Sounds like you tried to make one, but for whatever purpose, whatever reason, it didn't come to fruition. So is that his fault, or is that somebody else's responsibility?
That is his fault. And I would never cast aspersions against opposing counsel or Mr. Kahn.
What more could he have done?
What more could he have done?
Yeah.
Well, what he was supposed to do is go down to the trial court and do what Your Honor, Judge Levine suggested, and get with the clerk and designate those portions of the 2003 record that he needed for the 2011 record and actually submit those into the record and create a record for this appeal. That's what was supposed to be done. And it's interesting that the court asks that, and I have two major points on that. We got into this, and the very first thing that happened is it seemed like the appellant was struggling to find out how to file the notice of appeal. And so we started filing motions and guiding him along, trying to get even the notice filed correctly. And if the court looks, we filed motion after motion directing and saying, look, this is what you need to do. And if that wasn't enough, we actually filed in one of our, if the court looks, you'll find an order. It's order sua sponte of striking appellant's motion, a reply brief that we filed. In that reply brief, we actually went through, Ms. Bellin did, and told them step by step how to fix this.
But isn't the general case law that that they want, that the courts want us to judge it on the merits, if possible? So why can't we get to the merits in this case?
Well, I think the time has passed. I mean, and I've recognized, Judge Sicklin's, and I've recognized Your Honor's cases, the Servideo case and the Sahar case that deal with what is the appropriate record, and I'll get there, and I might as well just jump there now rather than kind of going through the way I wanted to. And let's talk about how much a party or the court has to assist counsel and whether that has been addressed by the appellate courts in the state of Florida. And it has. And if the court looks at the brief, and I'll read you the quote right now. It's from a case called Kaufman versus Baker. And that case is found at 392 Southern 2nd, 13, specific site, page 15, 4th DCA case, 1981. This is what it says. Where the record deficiencies are apparent, and there's no doubt that they were apparent, because we pointed them out 6, 7, 8, 9 times in motions filed with this court. Where they're apparent, and the record reflects that appellants are aware of them, we have an admission. They knew that there was a problem with the record, so there's no doubt we're that far. We find no need to award a second opportunity, even a second opportunity. We've given them 6, 7, 8 opportunities, orders from this court saying this is a problem. There's no need to award a second opportunity to supplement the record to hold otherwise would necessitate our leading the parties by the hand in an attempt to create an appellate record. This is more than hand-holding. This is, we've all played baseball. It's kind of like 3 strikes, you're out. We have 6, 7, 8 strikes. How long do we go? And the court will recognize if it has, we have filed a motion for attorney's fees. Mr. Weinstein, Dr. Weinstein, has spent tens and tens of thousands of dollars trying to get this thing framed. So to just go and give them another chance is extremely prejudicial. We're talking $100,000 here. But let's go right where we need to go. And right where we need to go is, fortunately, a decision by Judge Sicklin. And the decision, the name of the case is Sahar versus Green Tree Servicing. And the citation is 125 Southern 3rd, 251, direct site 254, 4th DCA, 2013. Again, Judge Sicklin wrote this, okay? The case is about what is the appropriate standard of review on de novo and what needs to be made and provided to you so that you can do your job. And he very clearly states there is a minimal summary judgment record that has to be brought up. And his minimal summary judgment record consists of 3 different things. First, the motion for summary judgment itself. So you can put some perspectives on this one paragraph that's contained in the verified complaint that they want you to consider. Without the motion for summary judgment, we don't have a framework to even focus on the allegation that he wants us to focus on. 2, the supporting papers that were for the motion, and the opposing papers and the evidence. And then 3, Judge Sicklin says correctly, all other matters of record pertinent to the motion for summary judgment. That is the minimal summary judgment record that has to be presented to this court so that this court can do its job. So this court can review whatever happened in the lower court. That's not that tough. And standing here, I don't understand why it wasn't done. We pointed it out, and Ms. Bellin's reply brief that was stricken, reading that just goes step by step by step, telling you what to do. And why wouldn't you heed that advice? Why wouldn't you heed the orders of the courts? I don't have any explanation for it either. But I can say this. We are all left with a problem. We're all left with the problem is that we have to somehow review a summary judgment order that we don't have. We have to review a motion for summary judgment that we don't have. And we have to review a reply that we don't have. And we have affidavits that we don't have. And when you look at the brief of the appellants, I went through under Judge Sicklin's rules, and I said, what did they cite to? And you know what they cited to? A verified derivative complaint and an amended final judgment. That would be in the file. If the file was this box, that would be contained in the file that's before you. If you look at the record and you say, what's not in that box? What is not in the record that should be in the record? What we tried to get into the record, what's not in there? Let's look. 10 things. The motion for summary judgment is not there. The response to the motion for summary judgment is not there. There was an affidavit filed by the appellant that was not there. The order granting summary judgment motion, that's not there. They filed for rehearing of that motion for summary judgment. That's not in the record. The order denying the motion for rehearing is not in the record. Mr. Weinstein's depositions, first and second, are not in the record, though he wants us to review a statement in the verified complaint that refers to those depots. Okay? The hearing transcript is not there. The discovery that relied on that he attacks Mr. Overwager in his motion for summary judgment for attaching certain discovery and that the court misconstrued that discovery, that's not in this record. The verified Fourth Amendment complaint from 2006, which has the same allegations, which put them on notice of that they needed to file a derivative case, is not there. So there's 10 critical items, and we're left with an empty box. One of the other things that I thought was really important, because I was worried that we would get into an oral argument where the parties were arguing things that were not in the record because we don't have anything in the record, is the Servideo case. And this is Judge Levine. Okay, it's Servideo versus U.S. Bank National Association, 46 Southern 3rd, 1105, 4th DCA 2010. It basically says if it's not in the record, you can't cite to it in your brief. If it's not in the record, you can't stand here and tell the court about it. And so what we did last night is we went through the brief to find out what would be left. What's left of the brief if you black out every single thing that is not supported by the record? And what you get is nothing. Nothing's left. All there is black. Every single statement in here is not contained in the record. Lastly, and I think one other issue I want to hit in the last 40 seconds that I have is that because he didn't create the record appropriately, he was forced to go back and rely for the very first time on the verified complaint. The arguments about the verified complaint, creating issues of fact that would defeat summary judgment were never made to the lower court, and he can't do it here. He forced himself in that position because he went to the box, and that was the only thing that was left. So with that said, Your Honor, we would respectfully request that the appellant's appeal be dismissed and denied. Thank you very much.
Thank you.
May it please the court. If this court merely felt that this appeal only had to do with the fact that there was an inadequate record of appeal, you didn't need oral argument from us to make that determination. What has already been ordered by this court and is made part of this record makes that absolutely clear that the court could have said the appeal is going to be dismissed, the judgment is going to be affirmed based on an inadequate record. And I know having oral argument before the 4th DCA is not a matter of right. It's in this court's discretion. So it's my belief, and hopefully my expectation, that there are larger issues presented by this case, and that this case has a certain unique set of facts. As I indicated, I could not find any other case law dealing with this type of circumstances that caused this panel to decide to hear this oral argument this morning. And that's where we stand. Counsel knows the record on appeal. They fought to keep it out, and then they do the proverbial, I gotcha, you don't have an appeal. Alternatively, we do have a verified pleading, which is consistent with everything that we said as far as our argument is concerned before the court. And in there, we make a record, actually, and then all of a sudden, the appellant's like, the appellee doesn't have anything to respond to because they went to so far of a length to strike everything that there's nothing else there. So, most respectfully, I would ask this court to either reverse the final judgment based upon the factual issue that we create through the verified pleading that is unopposed. There is nothing else for the court to look at. Or alternatively, allow us to put together the proper record that we both have. I mean, I tried to present it in front of this court on numerous occasions. They kept on striking it. They know what it says. It's almost like, what are they afraid of hearing before this court? What are they afraid of briefing before this panel that they've taken such measures to strike and attack the appeal at every step and at every juncture? Most respectfully, we would ask that the court reverse the summary judgment or allow us to prepare a proper record that knowingly exists. Everyone knows what it is. Everyone has copies of it in their possession. In fact, I would presume if you looked at our respective boxes, you would find the exact same documents there, being the summary judgment motions, the orders. I don't need to be clairvoyant to know that, but they got it. We got it. We all know what this court needed to hear, and we'd like the right to be able to present that to protect my client's due process rights. Thank you.
Okay, thank you, folks. All right, the next one up is Wines versus American Security. All right, good morning.
Good morning, and may it please the court. My name is Jeffrey Golant, and I represent the appellant, Milton Wines. If I may, I'd like to reserve 3 minutes of my time for rebuttal. The order that is under review in this case was decided on very narrow grounds. The circuit court ruled expressly, and the transcript reflects, that in order for a individual to be protected by Section 626-955-1D's prohibition on using borrower insurance information to solicit the sale of insurance, the borrower would have to allege that the borrower himself was the direct target of the solicitation. That's the issue in this case.
Wasn't the sale of insurance solicited well before this happened?
No, it wasn't, Your Honor. The insurance that caused my client's grievance was a transaction that happened long after whatever contractual arrangement between Wells Fargo and American Security. That's what brought him to seek declaratory relief.
This is a case of pure statutory interpretation, and in your brief you rely on a Florida Administrative Code, correct?
Yes.
To buttress your argument. Well, why should I care what an administrative agency says about a statute? I can read the statute just as easily as they can read it, and their administrative code, assuming it relates to the statute, and assuming it doesn't exceed the statute, is just their opinion. Why should I care about what a state agency says about a legislative enacted? And why isn't that a violation of separation of powers?
Well,
Two questions.
The Florida Supreme Court has held in the case I cited in our brief that it's entitled to deference. Now, it isn't, to the extent that obviously the regulation cannot overrule or change the statute, but what we have here is not that situation.
But I thought deference was, if we're talking about an environmental or some type of technical expertise, what type of technical expertise do you need to read a statute about insurance? Do I have to be an insurance broker?
I don't think it's necessary to be an insurance broker to read the statute, no. But I do think that the objective of the entire statutory scheme, which the agency is charged with enforcing, does convey it with some authority and some deference. This is not a situation, although it's been presented as one, where the administrative agency sought to rewrite the statute or change what the statute said. It's simply in light of the consumer protection purposes of the statute.
Do I have to rely on the administrative code for you to be victorious in this case? What if I say, look, I only want to look at the statute. I could care less what the insurance commission, whatever Florida, what the financial services says. Can you persuade based upon the statutory language?
I can, because the plain language of the statute doesn't include the words "to the borrower." That is something that the appellants are asking this court to read into the statute. And the question is whether the statute should be construed very narrowly or more broadly. We're not looking for an expansive construction of the plain language of the statute. We're looking for a common sense construction. The statute does not limit the solicitation to the borrower. And it's ironic, because in the briefs, the appellants argue that the heading of the statute is entitled Coercion of Debtors. And the argument goes, a debtor cannot be coerced if a third party is solicited. And that argument is just not logical. The way forced place insurance, as its name implies, works is a third party, a mortgage servicer, selects the insurance product and the borrower pays for it. So, and there's issues of conflict of interest and kickbacks and inflation of premium. So when a third party is making the purchasing decision and passing the bill on to the borrower, and if the borrower doesn't pay the bill, they run the risk of losing their property to foreclosure, that's a coercive situation. And
in your mind, there is no way under the statutory scheme to have forced planing of homeowners insurance?
No, there certainly is. And we've never said that there is no way to have forced placement of insurance. However, as the mortgage contract says, before insurance can be forced placed, the borrower has to fail to maintain their voluntary coverage. And it's been argued vociferously in the brief that, in the appellant's briefs, that my client didn't have appropriate insurance coverage. That's a factual question that would be very much in dispute in this case. He alleged that he did. And the reason why he brings this case is because he's gone through years of a frustrating experience where he's periodically charged by Wells Fargo for forced-placed insurance, even though he maintains his own insurance coverage. So we're certainly not arguing that it's impossible to force-place insurance. We're simply arguing that before a borrower's information can be transferred to a forced-placed insurer, the borrower would have to consent to that transfer. It's been argued in other cases, which are factually distinguishable, that the mortgage supplies the statutory requirement of express written consent. But it's a condition in the mortgage, even taking that argument at face value, and we would stipulate that it's not express, it's implied. But even taking that argument at face value, the mortgage does not authorize forced placement of insurance unless there's a condition that has to happen first, and that condition has to be a lapse in the borrower's voluntary coverage. Here, it's been alleged that there was no lapse, but there's been repeated forced place insurance transactions on Mr. Wine's account. Those facts must be taken as true. When reviewing a motion to dismiss, the circuit court didn't find those facts were not true. The circuit court assumed they were true. And the argument in the appellant's brief really attempted to make a factual representation to the court to kind of overshadow and even drown out the factual scenario that we're dealing with.
Well, let's go back to my original question then. When do you contend the solicitation took place?
The solicitation takes place when, in this case, American Securities Computer Systems apparently notified Wells Fargo erroneously that Mr. Wines didn't have insurance and communicated electronically with Wells Fargo to obtain authorization to place the insurance on Mr. Wines' account. Now, whatever contractual arrangement that was in place between Wells Fargo and American Security would have had to have happened long before that. And it's even discussed in the papers that in testimony before New York State regulators, American Securities Insurance Company's president refers to the tracking services that it provides to the mortgage servicers as an acquisition expense. So according to American Securities' own president, the way that they obtain force-placed insurance business from mortgage servicers is by providing these monitoring and tracking services, locating asserted lapses, in this case mistakenly asserted lapses, in the borrower's coverage, and then obtaining the authority to place that insurance. So in this case, there was a period of, some of it was within the Fladell class period, and some of it was was outside of the Fladell class period. It happened more than once. But in every situation that American Security force-placed insurance was placed, it was placed because American Security incorrectly notified Wells Fargo that Mr. Wines did not have insurance when, in fact, he did have it.
You're down to 1:42 if you want to save that for your rebuttal.
Yes, Your Honor, I would like to do that, please. Thank you.
May it please the Court, Peter Webster on behalf of American Security Insurance Company. I'll be presenting the argument for both appellees this morning. The dispositive issue in this appeal is whether Section 626-95511D prohibits only the unconsented to use of a borrower's insurance information to solicit the sale of insurance to the borrower. The answer to that is clearly yes. Appellant has conceded that he was not solicited regarding the sale of insurance. Accordingly, this Court should affirm. The issue presented is a pure question of statutory construction, which is a question of law, reviewable de novo. And of course, as this Court knows, the first rule of statutory construction is that if the language of the statute is clear and unambiguous, there's no reason to resort to rules of construction. The statute must be given its plain meaning. The meaning of Section 626-95511D is perfectly clear. It's intended to protect borrowers from the unconsented to use of their insurance information to solicit the sale of insurance to them. Because the language is clear and unambiguous, there's no reason to resort to rules of construction. The statute has to be given its plain meaning. However, a resort to the rules of statutory construction reinforces the plain meaning of the words used. The heading of Section 626-9551 is Favored Agent or Insurer Coercion of Debtors. From that heading, it's apparent that the purpose of the section is to prevent improper coercion of the debtor or borrower to purchase insurance in connection with the loan transaction from an agent or insurer favored by the lender. And in fact, the appellant concedes that on page 10 of his reply brief. He concedes that's the purpose of this statute.
Mr. Russell, let me ask you this, though. This is what actually, and I suppose this is a good reason why in certain cases we have oral argument, because what your opponent suggested, and which did not jump out at me as I prepared for this oral argument, is that Mr. Wines apparently throughout the proceedings below was trying to get somebody's attention to say, yes, I know that if I don't maintain the proper insurance, that State Farm has the right to do this, but that was in fact the whole point of the controversy below. He maintains, Mr. Wines maintains, that he always had proper insurance. So what about that issue? And you may say, well, you know what, Judge, that really has nothing to do with the issue before this court. But
Judge, I'm glad you asked that, because the trial judge in this case asked plaintiff's counsel exactly the same question. This is on page 150 of the record. The court said, well, whether or not that is the case, it doesn't really affect what my decision here today would be, right? Whether or not he was current or kept up his insurance or not, That really isn't the issue. And Mr. Golan, on behalf of the plaintiff, said, I agree, that's not the issue. This is a declaratory judgment action brought pursuant to Section 626.9551 1D to prevent the use of the borrower's insurance information. And unless that section covers the situation that occurred here where the appellant has conceded he was never solicited, unless that statute applies when there's no solicitation of the borrower, there's no case. And the trial judge got it right. And so
there may be an action, but not pursuant
not this
to
action.
one. Well, could you address the Florida Administrative Code?
I'd be delighted to, Judge. It simply has no bearing on the outcome of this appeal, and there are a whole bunch of reasons why. First, on its face, the rule purports to interpret Section 626.9521, not Section 626.9551, and the appellant has never explained, either in the trial court or here, how the rule can be read as interpreting a statute other than the statute it purports by its very language to be interpreting. Second, even if the rule could be read as purporting to interpret Section 626.9551 1D, there's no reason, as Your Honor indicated, to defer to an agency's interpretation of a statute if either the statute is plain and unambiguous and there's no need for construction, or if construction doesn't require agency expertise. That's clearly what we have here. The language of this statute could not be any clearer. Third, again, assuming that the rule can be read as purporting to interpret Section 626.9551 instead of the rule itself limits use of policy information only, and this is a quote, to substitute, replace, change, or extend an insurance policy, and the complaint doesn't allege the use of appellant's insurance information for any of those purposes. And finally, as Your Honor alluded to, again, assuming that the rule can be read as interpreting a statute it doesn't say it's interpreting, in that case, the rule would clearly impermissibly enlarge or modify the statute. Why is that so? First of all, because Section 626.9551 1D prohibits only the unconsented to use of a borrower's information to solicit the sale of insurance. The rule doesn't even mention, let alone require, a solicitation. Moreover, on its face, it's apparent that if this rule is intending to interpret Section 626.9551 1D, it greatly expands the scope of the prohibited activity beyond that prohibited by the section. That's explained far better in the Hofmeister decision than I could explain it to you here today. We cited that in our briefs. For all of those reasons, there's no reason to look to this rule. It just has nothing to say about the issue before the court. Back to the statute itself, I adverted to the heading of the statute and to the fact that appellant in his reply brief agrees that the purpose is what we say it is. In addition to that, paragraphs A, B, and C of subsection 1 of the statute all protect the borrower from various ways that a lender or affiliated entity might coerce the borrower into purchasing insurance from a favored agent or insurer. Paragraph A protects the borrower from being coerced into obtaining insurance from a particular insurer, agent, or broker. Paragraph B prohibits the unreasonable rejection of an insurance policy provided by the borrower. And paragraph C protects the borrower from being required directly or indirectly to pay a separate charge in connection with the handling of any insurance policy required in connection with a loan. So read in pari materia with paragraphs A, B, and C, as it must be, it's clear that paragraph D is part of a statutory scheme intended to protect the borrower from unwanted solicitations for the sale of insurance. It just couldn't be any clearer. That's the whole basis for their declaratory judgment action. I submit to your honors that the trial judge got it right. He correctly relied on the Southern District / 11th Circuit decision in Sultan and the Miami-Dade 11th Circuit decision in Hofmeister. Unless there are any questions, we request that you affirm.
Okay, thank you.
The appellees argue that the court should look at the plain meaning of the statute. And at the same time, the appellees ask the court to add words that are not in the statute. And those words are to the borrower. Those words are not in the statute. It is not in the plain language of the statute. And it is not consistent, as we've already discussed, with the goal of protecting the borrower from coercion. Another logical flaw in the argument that was just presented was that the policy wasn't intended to substitute or replace a borrower's policy. But that's exactly what force-placed insurance does. It's only available when the borrower has no policy and a policy needs to be placed in replacement of that policy.
Let me ask you this question. Let's assume, and I know you dispute this, but let's assume for argument's sake, and let's take Mr. Wines out of it. Let's call this person Mr. Jones. Mr. Jones has this exact same mortgage with Wells Fargo. Mr. Jones just for whatever reasons believes that he should not maintain hazard insurance. He doesn't want to, or if he does, he was able to go online and he's got $10,000 worth of hazard insurance that he's paying $100 a year for, and Wells Fargo says, wait a minute, clearly this is unacceptable. This is not in keeping with the hazard insurance requirement of the policy of insurance. In that situation, again, assuming that Mr. Jones intentionally underinsured here, what is a Wells Fargo to do in a situation like this?
In the situation Your Honor describes, Judge Sicklin, Wells Fargo is perfectly within its rights to force-placed insurance. And conversely,
why?
Because the mortgage says so. The mortgage does impose an obligation on the borrower to maintain insurance. And if the borrower breaches that obligation, then the mortgagee is allowed to replace the insurance with force-placed insurance. There's no dispute about that.
How do they get the information to know, excuse me, that there's a necessity for that type of placement?
Well, until the recent developments in the industry, the mortgage servicer would monitor their portfolio themselves. Recently, and I think it was discussed.
You're saying that the monitoring is the problem?
The monitoring is the problem, because in this case you have monitoring being done using systems that Mr. Wines maintains are deeply flawed and that have failed in his situation many times, and it's being done by the insurance company that would provide the insurance and that has a business interest in procuring the insurance placement.
You're saying the monitoring is okay as long as the lender does it, not if the insurance company does it?
It's certainly okay under the statute. That would not trigger any issue of consent to the sharing of the information. So there would be no issue under the statute whatsoever if the servicer were doing its own monitoring. Now, if a third party, in this case American Security, is doing the monitoring and there's a breach of the mortgage, the issue is different. And that issue, as discussed in Sultan and in Hofmeister, was whether an actual breach of the mortgage, or I'm sorry, whether by signing the mortgage that talks about forced placement, that constitutes express written consent as required by Section 626-9551. That's a different issue. But before you get to that issue, there has to be a factual scenario in which a mortgage was signed and the precondition to forced placement, lapse of the borrower's voluntary coverage, actually happened. The mortgage plainly does not authorize forced placement when the borrower maintains, as Mr. Wines did, insurance continually. And that's the very critical distinction in this case.
But your opponent's arguing, though, but that's not how you framed your declaratory action. You were really looking for a declaration that in this particular situation, State Farm, in cooperation with American Insurance, really took advantage of the situation and did the same type of solicitation you're suggesting that the statute prohibits.
I believe that the appellees really have mischaracterized the allegations in the complaint. What the complaint alleges is that Mr. Wines had been subjected to erroneous forced placement by an entity that he never even heard of, American Security Insurance Company. He would have never known that he was dealing with American Security Insurance Company if he had not actually taken the step of hiring a lawyer out of the frustration he was experiencing. And because he did never know that American Security Insurance Company was involved, he never had the opportunity to expressly consent to American Security's involvement, or was not given the opportunity to object to that involvement. And that's the right the statute confers. The statute requires express written consent or at least the opportunity to object. But there's no disclosure whatsoever, and it's counterintuitive that American Security is actually operating on Wells Fargo's behalf, monitoring the borrower's insurance company, and force placing insurance in the name of Wells Fargo.
Well, why is the provision for hazard insurance under the mortgage, why is that insufficient for consent?
It's not express written consent to disclosure to the third party that is actually receiving the information.
Well, it's consent for forced placement, isn't it? It's
consent for forced placement. It is. And it's certainly not sufficient in this factual situation.
So your theory, they'd have to have their own insurance company to be able to do it?
No, we're not saying that at all. They would.
Well, I wouldn't presume you would, but I mean, how would you logically do it then? They have to give that information to an insurance company at some point. So you're saying if you have a recalcitrant homeowner who does not want to do what the mortgage requires, they're not going to ever agree to send it to that information being sent to a third party, and how would you ever enforce that forced placement?
Well, all they have to do is either obtain consent or provide the opportunity to consent. It's a disclosure right that's provided. So what they cannot do under the statute is transfer the information and use it to procure insurance without the borrower even knowing that it was done or provide it to that party.
What if they refuse consent?
If they refuse consent, then they don't have to make the loan. That could have been made a condition of the loan. It wouldn't have been difficult at all. And at least if that had happened, Mr. Wines could have read his loan documents and known that the party that he had the grievance with every time he was wrongfully forced-placed insurance was American Security Insurance Company. He didn't even know that. And I would submit that under the statute, he is entitled to know that and must at least be given the opportunity to object to that. Few borrowers would, very few would, unless they have a problem, as Mr. Wines did. But even if Mr. Wines had consented or been given the opportunity in advance, then he wouldn't have recourse under the statute.
Okay, great. Thanks,
Thank you.
All right, our next one up is Reynolds versus State. Reynolds is the last one, right? Okay, I left my docket sheet upstairs. No, I want to make sure that I have my docket was right here. Morning, please proceed.
May it please the court. My name is Valerie Lennon, and I represent the appellant Pasco Reynolds. At this time, may I reserve 2 minutes for rebuttal? There are a total of 5 issues before the court today. I'm down to 8 minutes, so if we don't get to all 5 issues, I'd ask to stand on the briefs on those issues. I would like to try to focus on the first issue first, and that being that the trial court erred by allowing testimony about out-of-court identifications not made by an eyewitness to the crime or events or a victim to the crime or events. It gets a little convoluted about impeachment, opening the door, and those sorts of things, but the bottom line is that the original testimony was inadmissible. To back up for a minute, the co-defendants here are brothers. The state questioned the other co-defendant, his girlfriend, that they showed her. There were 2 surveillance videos here. So one from a convenience store early in the evening and one of the homicide convenience store in question. The girlfriend identified both co-defendants by viewing the video. Then later the state asked the co-defendant's mother if she was able to identify her sons in both the videos. She said she didn't remember doing that. Over objection, then we get through the whole, refreshing recollection, which didn't go according to the book, impeachment, opening of the door, and all of that. So this court held in the Spencer case, and the Florida Supreme Court adopted that rationale in the Aybar case, that Section 90.802C is intended to be from a victim or an eyewitness, a person that is actually one of an identification of a person made after perceiving the person. This court interpreted that to be that it must be an eyewitness or a victim to the crime. The mother and the girlfriend were not eyewitnesses. They were not victims to the crime. So the harm here, the bigger picture being, anybody can show up in court and say, yeah, I've known the defendant for 5 years, 10 years, 15 years, and I'm telling you that's him on the video.
But the video wasn't of the crime, was it? The video was of an occurrence that happened before the crime.
That's where we get to the problem. There were 2. And so when the state plays the video of Tonya North's police interview, they show her both videos, both of the one earlier in the night and one of the actual events, and she identifies her sons in both of those videos. And so the problem with that is that the jury's got to be the finder of fact. They've got to be able to look at that video and decide if the 2 men in the video are the 2 defendants in front of them. And if they can't make that determination, she's their mother. The inference is a mother knows her children when she sees them. Surely if she says that's her children, that's got to be them.
But at trial, the attempt to have the mother identify the individuals at the crime scene video was sustained, wasn't it?
And then it went through the opening the door, if I'm remembering right. It went through they said they opened the door on cross-examination. Well, it's already out there. The defense has got to deal with it.
Okay, and then the issue was whether or not she could identify the individual in the video, what, 7 hours or something prior to the incident.
Right.
And then she had the loss of memory.
She said, I don't remember saying that. And then instead of refreshing her recollection, here's a transcript of the interview. Does that refresh her recollection? Then the prosecutor just proceeds to read the interview, the transcript of the interview to the jury. So, and then that's also goes back to the girlfriend as well, because she identified them in both the videos, not just the community market from, the mobile gas station from earlier in the evening. And she says, yes, that's both of them. So certainly the girlfriend should know her boyfriend when she sees them. The mother should know her sons when she sees them. The bottom line is that neither one of them were eyewitnesses or victims. So all of the other about, was it the earlier in the evening or was it the actual crime itself, that really should have just been left to the jury.
Why isn't it harmless error?
Because it's the gunmen in the video, their faces are masks. So there's some, I believe there's some pictures of tattoos that came in earlier. It's not harmless because, well, let's start with the other well, he wasn't a co-defendant, but the informant, I guess, that said that he didn't actually witness the crime, but he drove with them. And he went in first, did the surveillance, came back out, claimed he didn't know anything about it. There were a lot of inconsistencies in his testimony. I picked out at least 9 that I was able to discern from the record that were argued to the court. So there are real problems with the credibility of his testimony. Probably the most glaring is that he testified he didn't know anything about what was going to happen, but the store clerk said that the way, I believe his testimony was the way he looked at me, there was something about that just didn't seem right. So there's some real credibility issues.
Well, that's credibility as it relates to his involvement. But what about the credibility or the other evidence regarding the defendant's involvement?
Well, there wasn't any. Besides this witness's testimony, there's no DNA, there's no fingerprint, there's no firearm. It's this witness and the mother saying on this, this testimony of the mother and the girlfriend saying, that's my son, that's my boyfriend in the video. That's it. So again, the harmless error analysis doesn't focus on the weight of the evidence, but the impact of the error here.
You have the car.
Sure.
Okay.
Yep.
You have the tattoos, I believe, were in
The
evidence
tattoos.
as well. So
Well,
there's a lot of that other evidence as well. It wasn't merely a no DNA, no
Right.
gun, no nothing else.
If you look at the pictures of those, at least on my end in the record, the pictures of those tattoos are a little fuzzy, and then they're blown up from the surveillance video, and they're a little fuzzy too. So it wasn't an open and shut case against these 2 co-defendants. It's just the testimony of this informant.
So it seems to me it's that it was improper impeachment in terms of the style, perhaps, but ultimately it was impeachment. So is that, you're saying to us that in and of itself makes it reversible error?
No, what makes it reversible error in and of itself is that the testimony itself wasn't admissible.
And for impeachment purposes, as opposed to substantive evidence, and they had done it properly, I'm sure you'd be arguing it, but you'd probably maybe not as vociferously.
Well, then we have to go through the whole 403 analysis. Is it unduly prejudicial? Is it unfair? And in this case, I would say it's unfair. Just let the jury make this decision. That's what their role is. Let them make the decision. Let them look at the video.
Fair to impeach somebody who testified previously that ID, and then they come into the courtroom, not unheard of, and say, I don't remember. And the prosecutor or whoever, the defense attorney who's now confronted with a recalcitrant witness, tries to impeach the person, refresh their memory. You're right, does this refresh your memory? Why? I mean, that's pretty standard fare.
So there's 2 parts to that question. First of all, we're talking about Mr. Reynolds' right to a fair trial. The second part of that, it wasn't sworn testimony, it was a police interview. So if she says, I don't remember saying this, no problem.
What's a prior inconsistent statement? So
prior
it's
inconsistent
not sworn
statement.
testimony,
Right.
but it's a prior inconsistent.
So then I would argue then it still goes back to the weighing. Is Mr. Reynolds unduly prejudiced? Is this unfair to him to have the jury hear his mother look at a video that she didn't witness, that she wasn't a victim, and say, yeah, that's my son's?
So it sort
right
of
there.
cuts 2 ways, having the mother testify. I mean, you're right, it's impactful, but it also is less likely for a false identification, too.
I wouldn't go that far in saying that. I would certainly want, an expert in that to answer that question. And I have about 1:15 left. May I reserve that for rebuttal? Thank you.
May it please the court. Mark Hamill for the state of Florida. As for the initial questioning, the reply brief said the state's argument appears to miss the indisputable point that the original question, which triggered all the subsequent impeachment, was inadmissible. And you just heard that. I'd like to draw the court's attention to page 1868 of the record, and in the PDF, that's 1978. When the mother was asked whether she made a prior identification, she said that was not true because he switched the pictures. So when she says that is not true, she's making a denial. So this is more than just I don't remember. There were several questions asked before the state began the impeachment questions, and in answer to one of the questions, she says, that's not true. So she's denying that she ever made the identification before. That being the case, it's proper for the prosecutor to then go to impeachment rather than refreshing recollection, which he did try to do. And she said at that point, I don't remember. But she already said it wasn't true. So there are a couple of objections were made to the trial court saying this shouldn't be done because they should be refreshing the memory. The judge saw what happened. It was clear from the context of the prosecutor's questioning that at that point it was proper to impeach this witness because she was saying it wasn't true that she made a prior identification. In appellant's reply brief, they actually rely on Alvarez, which is a not too old case from this court, which is strange because the language from Alvarez says even non-eyewitnesses may testify as to the identification of persons depicted or heard on a recording as long as it is clear the witness is in a better position than the jurors to make those determinations. Here we have a mother identifying her two sons, and we also have a girlfriend who saw these two individuals on the night before the robbery and murder took place, so she knew what they were wearing. We definitely have two people who were in a better position to make identifications, and the identifications that were made here were the girlfriend identified both at the mobile gas station. The mother only identified in court the co-defendant. He wore a distinctive jacket, an M&M jacket. So she said it was him, and then there was dispute over whether she also identified the defendant from the mobile gas station, and also whether she actually identified the defendant from the surveillance video of the convenience store. So that's how the issues were. And it is a little convoluted because when it came to the mother, the prosecutor asked, I counted about 50 questions of identification during her testimony, showing her pictures of the car, surveillance video stills, and the girlfriend probably asked about 30 questions. So there were maybe about 80 identifications that the prosecutor asked. The questions by the prosecutor were proper. The prosecutor was asking in a present sense, can you look at this? Can you identify this? It's not an out-of-court statement. It's a perfectly permissible question to ask a witness on the stand. And when he got answers that were inconsistent with what the witness said earlier, he tried to refresh recollection, and he moved to impeachment when he had to. So that's what happened in this case. There was no improper questioning. The issue the state has with the harmless error analysis is there was some powerful evidence in this case in the mobile gas station surveillance video. These two brothers, according to the girlfriend identified the brothers, these two brothers went into this mobile gas station 7 hours before the crime that took place in this case. And especially the co-defendant was wearing some pretty distinctive clothing. A long green shirt that came down past his waist in very baggy black pants. And if you look at the surveillance video versus the surveillance video of the mobile gas station versus the surveillance video of the convenience store, it's hard to say that that's not the same person just by looking at the video. So there was some powerful evidence in this case, but I mean, the most powerful was Marcus Johnson. Marcus Johnson was not charged, but he testified that he was in the car, he went into the convenience store, and he's on the surveillance video. It's not like he's making this up and there's nothing to put him there. And he's another one who made an ID. He wasn't present. During trial, they showed him the video and said, do you recognize those people in the video? He's like, yeah, those are the two co-defendants. That's what they were wearing when they got out of the car with me. They put on the bandanas and they had guns. So if you were to take her argument that you could never have someone who wasn't there testify about identifications, and he shouldn't be allowed to either. But of course, under Alvarez...
What about the Aybar case? Can you distinguish that?
In the Aybar case, said the hearsay exception, and we're talking about the hearsay exception for a statement of identification made after perceiving a person, does not apply to out-of-court statements made by persons other than victims or witnesses to a crime. So in that case, you had police officers coming in and saying, these people made identifications. So the police officers were testifying to hearsay. You didn't have someone in court saying, I can identify the person. So you had somebody who wasn't at the scene, they're only testifying to a hearsay statement. So it doesn't come in as a hearsay statement. I think in In Aybar, they said that's permitted in some states. We're not going to go that far in Florida as far as the hearsay exception for eyewitness, for identifications. So that's specifically limited to eyewitness identifications for identification. But in our case, it was impeachment. So the state did not rely on that exception. They initially wanted to, and then defense said, no, Aybar prohibits it. The trial court read Aybar, and the trial court said, yes, I agree with you. Aybar will not let that in. And then at that point, the detective testified, but it was only for impeachment. It wasn't going to be used as substantive evidence. And then at that point, the defense opened the door, and the judge allowed it in because it was because the door was open. So the judge followed Aybar. So Aybar is not an issue in this case. And I'm just going to rely on my brief unless there's any further questions, and ask that you affirm. Thank you.
Thanks.
May it please the court. Your Honors, I was counsel for Mr. Alvarez twice now. There was no objection under this particular statute, so it wasn't an issue in the Alvarez case. We still don't get past the 403 analysis, whether the prejudice of having the defendant's own mother testify or show a video of her identifying her sons, that is unduly prejudicial for Mr. Reynolds. And as always, again, the harmless error, it's not about the weight of the evidence.
It's prejudicial in the sense that that's pretty damning evidence, but it's still probative. The question is it
unduly prejudicial, Your Honor.
Yeah, well, why? Why is it unduly prejudicial to have a mother testify? I mean, that seems to be the type of witness that the prosecutor would want. Of
course the prosecutor would want it because of what the inference brings. The inference is, those are my children. Of course I know them when I see them. What I'm trying to get through is, just because the witness is a strong witness for the state doesn't make it undually prejudicial. That's unless correct. You can enlighten me. Unduly prejudicial being because we have surveillance videos here. Just let the jury determine it themselves, right? I don't agree with the state's analysis. I'm out of time here, if I could just wrap up quickly. I don't agree with the state's analysis about Aybar and Spencer. This court was very clear, the Florida Supreme Court was very clear. Eyewitnesses and victims. Bottom line, no exceptions. And with that, I would ask the court to reverse the conviction and remand for a new trial. Thank you.
Thank you very much. All right, that's our morning docket, and we will be in recess.